SJC-11398, Commonwealth v. Roderick James Taylor.
Thank you.
All right, counsel, good morning.
Good morning, Your Honor. It's been too long. All right, so I represent Roderick Taylor. This case is very simple. When nearly 6 months after arraignment and more than 8 months after his arrest, the defendant still had not received the most basic, automatic, mandatory discovery, defense counsel announced in open court that he would not waive Rule 36 until he received it. Despite counsel's clear notice, his repeated clarifications of the outstanding discovery, and his repeated reassertions that he was not waiving Rule 36 until he received it, the Commonwealth failed to produce this automatic, mandatory discovery until the eve of trial, 21 months after the defendant's arraignment. This inexcusable delay, in the face of clear notice, violated the defendant's right to be tried within 1 year under Rule 36B, and therefore requires dismissal of the indictment.
I'm sorry.
Go ahead.
When did you say when do you say that it ripened into a Rule 36 dismissal?
Well, that's a technical question. It ripens into a Rule 36B dismissal when the 365th day
What day would
expires.
that have been?
Well, I didn't actually look at it that way. What I can say is there are 448...
But don't you have to look at it that way? Because isn't that the day he should have filed the motion?
Well, respectfully, there's nothing in the case law that says on the 365th day you must file the motion or else there's some prejudice. The way it's universally applied is we decide once the motion is filed, have 365 or more days expired. I don't submit, in answer, I think, to the implication of your question, or I reject the notion in answer to the implication of your question, that if on the 365th day you do not file a motion, you lose anything. I don't think that's the case. What, in fact, I would say is that...
But it's curious that the motion hadn't been filed. If he really meant for Rule 36 to apply, after, the 360 days was gone, I mean, if it was that obvious, why wait for the discovery? Why continue to ask for the discovery and continue to lead the judge on into thinking that we're going to have a trial in this case?
The motion was filed before trial.
The motion was filed on...
But it wasn't filed. I mean, why wait? Why, if this Rule 36 was so clear, why not file the motion after the 365 days you said you say should require dismissal?
Well, again, I would say that it's never the case that you can. The reality is you can't read the decision maker's mind. So I don't think that it's the case in any case I've ever read or any lawyer I've ever talked to that they look at it this way, the way you're describing, that trial counsel is sitting there with a calendar checking off saying, I've got this amount of non-excludable delay. These things are always litigated.
But have we ever seen a case where the scenario played out the way it did in this case, where the defendant is saying, defense counsel is saying, I'm not waiving Rule 36, but I want my discovery? We've never seen anything like that either, have we?
Yes, we have seen cases like that. That in the BBA through Goodwin Proctor actually cites at least three. First, Amadon. Second, there are three. I can't remember the cases, but they're in the BBA's brief. But it's definitely been the case that there have been cases where the court has held, Wysocki is the second one, and a third is Silva. That's right, a pre-Rule 36B case. All of these cases, the court held essentially that the Commonwealth's failure to provide discovery after a reasonable amount of time, which is, there's not great clarity on this, but I think is fairly determined to be 30 days, more or less 30 days, is where it's automatic mandatory discovery required under the rules, is going to be is no longer grounds for exclusion of the time. So the SJC has clearly, this court, yes, and the appeals court have recognized that after a certain amount of time, the Commonwealth's failure to provide discovery is no longer a basis for exclusion of time. I think it's important to state right off the bat that Judge Neal's interpretation of Rule 36, that is that you have to object on every single date, would transform a tool designed to enforce a constitutional right to a speedy trial into an obstacle to the enforcement of that right with grave consequences.
Wouldn't you agree, though, that whatever may be the rule going forward, his interpretation is not one that was unique to him. The idea that a defendant needs to make clear, not just on January 27th, but March 6th and going forward, that this objection is continuing.
Well, I don't think there's any case law that supports his specific restrictive interpretation. I think that the case law, and it may certainly be that there are other judges who have said this, and I think that he's drawing on case law. He quotes cases that say where the defendant acquiesces in a delay, then that time shall be excluded. The difference is he's saying that and the troubling thing, I don't know if, I would think that it's certainly possible that there have been lots of judges in the trial courts who have taken this same view, that if you don't object to a continuance, then that is going to be deemed to be acquiescence in the delay and therefore excludable, and you'll cite the cases which say where there's acquiescence in the delay, that's excludable. The problem is that he ignores the corollary principle that where the point of the objection, the contemporaneous objection, is notice. Notice is the key, Commonwealth v. Borden, and that's the key to this case. In this case, starting on January 25th, 2007, and then again on May 17th, 2007, and then 4 more times, defense counsel says clearly on the record to the Raj, Judge Hinkle, who is the only judge who handles this case all the way up until the motion to dismiss is filed, and to the ADA, David Meyer, who's the only ADA handling this case up until ADA Zabin takes over on December 4th, and then he repeats it. He says repeatedly to these people, I am objecting to the any further exclusion of time until I get my mandatory automatic discovery. And he identifies what that discovery is with great precision.
I understand that, but obviously, as Judge Neal found, one can interpret that not the way you do, or Mr. Swanley did, but that it really was meant, in the first example, from January 25th to March 6th, which was the next hearing date, and going forward. Because all these other events are happening, and either Mr. Swanley or somebody from his office or somebody from the DA, there's a lot of activity going on where nobody's saying anything, really.
Well, when you say a reasonable person can interpret that, I'm not quite sure
Meaning
what you mean by
that was
that.
Judge Hinkle's comment about whether she was referring to the sort of putting on the record that the Rule 36 objection was going forward, as Mr. Swanley was suggesting, or did it mean, as Judge Neal read it to mean, okay, I get it. From today until at least the next hearing, the clock is told. I mean, the clock is running. The clock is running.
Sure. The best answer, I think, is Judge Hinkle, the Raj. What does she think it means? Because she's the one, Judge Neal is trying to look back retrospectively.
Right.
I would point to her comment on May 17th saying everybody should understand that Mr. Swanley is relying
Right,
on
but
his
then
right.
she goes on to say, yeah.
Unless there are other reasons for exclusion. Yes, okay. But for other reasons for exclusion, so let's produce what are those other reasons for exclusion? I guess, for example, if counsel doesn't show up, arguably that might be a point of exclusion. I think even if you exclude all those instances where neither counsel showed up, then you would still have more than 365 days. But the best example of her understanding of the meaning of this is found on December 27th, 2007, where Record Appendix 211, where she says, and I quote, "The Commonwealth is on notice," that's important, "the Commonwealth is on notice that Mr. Swanley has taken the position, frankly, I think, throughout its statuses, that his client is standing on his Speedy Trial Act rights here." So it's clear to Judge Hinkle, and I think that's the only person who matters, because she's in the courtroom, and she's the deciding judge here, that what his position is. It's clear that his position is not this restrictive notion that he's only objecting until the next court date, and then for some inexplicable reason stops objecting. And that's the other point, I think. Forget about, put aside Judge Hinkle's clear understanding of the meaning of that objection. It defies logic and reason that he would object. It's clear what his position is. There's no gamesmanship going on here. He's not trying to insert some issue in quietly. It's clear. I've been waiting for 8 months for the most basic kind of discovery. The audio tape recordings and transcripts of these witness interviews of the people who are accusing him and testifying against him. And I need that. I can't prepare for trial. And it's been 8 months now, and you know what? I'm going to assert my client's Rule 36 rights until you give it to me. It's not gamesmanship. It's not some trick. And there's no reason.
I'm not suggesting that it is.
Right.
I'm not.
And okay, the Commonwealth does. There's no reason. The Commonwealth doesn't suggest that they explicitly assert that that's what's going on. But there's no reason on March 6th that concern would evaporate. And indeed, it doesn't. May 17th, he reasserts this view and says, I've never waived Rule 36. This has been my position. I'm waiting for this. So I submit that it's clear Judge Hinkle understands the position. It's clear the record makes clear what the position is, and logic indicates that there's no reason he would withdraw this objection on March 6th and suddenly not care about.
Remind me, did Mr. Swamley bring a motion under Rule 14?
I'm sorry, did he bring what?
A motion under Rule 14?
Yes, he did. He brought, and I'm glad you raised that. It's been periodically raised here by Judge Neal and the Commonwealth. He filed a motion to compel back in November of 2006. And on the same day that the Commonwealth gave him a big pile of discovery, he says to the court in November, I'm going to hold back that motion to compel until I've looked at this information. But then he doesn't pursue the motion to compel. And Judge Neal says, aha, you didn't pursue the motion to compel, therefore your Rule 30, that's a reason, that's your tool for fixing this problem. If you really care about the discovery, file a motion to compel and pursue it. That's a red herring, respectfully. These are two separate issues. You have a constant, and the BBA most expansively.
There's a tool which is Rule 14 to get discovery.
Getting discovery, yes.
And if there are delays in discovery, that's a tool that one can use to seek sanctions and court orders and all of that stuff.
Yes, and that is one relief. That is relief for that issue. Simultaneously, a defendant has a constitutional right to a speedy trial, and the
But is this a Rule 36 analysis, or is this a constitutional analysis that you're arguing? Because they're entirely different.
Right. Absolutely. Fair point. It's clearly a Rule 36B analysis. I'm not, and I don't mean to suggest otherwise, I'm not suggesting that we have a constitutional claim here. But Rule 36B is clearly implemented to provide a mechanical implementation of the constitutional right.
But Rule 14 is part of the Rule 36 case management concept. Or the entire rules of criminal procedure. Rule 36 is a case management tool, and one of those tools is Rule 14. And here you have Rule 14 that's readily available as an expressed request for this discovery, and it was used and then withdrawn.
Well, indeed, okay, there are several issues quickly. I don't have a lot of time, and I want to get to the second issue. Nothing in Rule 36B or the notes or the case law interpreting it says that if you fail to pursue your Rule 14 remedies, you are therefore precluded from obtaining relief under Rule 36B. The basic point is you have an entitlement to a speedy trial under Rule 36B, which is separate and apart from your entitlement to sanctions under Rule 14. Counsel did, in fact, pursue his motion for sanctions in May after he had of 2008, right before trial, right after he had filed his motion to dismiss for speedy trial grounds. The court, predictably, said, did you get all this stuff? Yes, I got it on May 1st, 4 days before trial. So how are you prejudiced? Well, I'm prejudiced because I've got a trial in 4 days, and I've got all this information I have to go through, and now I'm going to be going through this instead of preparing for trial. That's all in the transcript of the hearing on the motion to compel. Judge predictably says, well, tough. You're going to be able to deal with it during the trial. If in some way you're prejudiced during the trial, bring that up. No motion for sanctions denied. That's very instructive of the situation here. Motion to compel, if the Commonwealth dumps on you at the last minute, as they always do in the Commonwealth, in Suffolk County specifically, this huge amount of information, the court is going to say, what prejudice? Motion for sanctions denied. That's totally separate from the Rule 36B problem. comes to trial 21 months after he's arrested, after he's arraigned, 23 months after he's arrested, sitting in jail the whole time, witnesses' memories fading and so forth. That prejudice is not required, but it's certainly an issue, a motivating issue. So I submit that these are separate things. Now, I need to discuss very briefly the second issue, which is not a trivial issue. This court in Commonwealth v. Lewis just this year issued a decision which I think is on all fours. I didn't quote it in it came out after my blue brief, but my mistake, I didn't quote it in my reply brief. I submitted a 16L letter. I submit controlling on all fours here, where the Commonwealth, the prosecutor, calls the defense counsel a bald-faced liar and says that the jury would be violating their oaths as jurors if they believed his theory of defense, then that is prosecutorial misconduct of the highest order. It is a federal constitutional violation. It is so severe. And in any event, in this case, counsel's argument was not anything like a lie. He proved that the complaining witness, Martin McRae, had motive, means, opportunity to commit the crime, and also expressed consciousness of guilt in repeatedly lying to the police. And in that context, this court has held that where you have motive, means, opportunity, and consciousness of guilt, that is sufficient to establish proof beyond a reasonable doubt that a defendant is guilty. If that is the case, Commonwealth v. O'Loughlin and Commonwealth v. Lau, cited in my reply brief, if that is the case, then it must be the case that a defense counsel can argue motive, means, opportunity, and consciousness of guilt is sufficient to make a reasonable argument. So it is even more inappropriate for the prosecutor then to stand up and call that a bald-faced lie. That is outrageous, a violation of the constitutional right to due process of the highest order, and that is a separate basis for reversal. Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the Court. Sarah Montgomery on behalf of the Commonwealth. I will be addressing the speedy trial issue in this case, and Assistant District Attorney Kathleen Celia will be addressing the prosecutor's closing argument claim. Also with us is Assistant District Attorney, Chief of the Homicide Unit, Ed Zabin, and also is the victim's family in this case is in the audience. Your Honors.
And the trial prosecutor.
And the other trial prosecutor, David Meyer. The only issue before this court is whether the mechanical operation of Rule 36B, as written, requires dismissal of the defendant's second-degree murder conviction. It does not.
So why weren't the tapes, the audio tapes, presented in a timely fashion? I mean, the transcripts, I take it, of audio tapes had been given. Why does it take so long to produce audio tapes?
We do not know on this record why the audio tapes were not produced until April of 2008.
Were the transcripts produced?
The transcripts were. And the reason we don't know is because when a discovery dispute arises, the defendant is to file a Rule 14 motion to compel or sanctions to adjudicate the dispute. And
So
here,
you don't have to do anything and you just wait until there's a motion? That's not right. It's automatic discovery.
I agree with Your Honor that when there is automatic discovery, it is to be automatically provided to the defendant at the
pretrial
conference. If it is in the possession, custody, and control of the Commonwealth or its agent at that time. We disagree with the fact that the audio recordings are automatic mandatory discovery where we provided the transcripts of those statements thereof, and Judge Neal specifically found this. In fact, when the defendant...
Well, what if the transcript's not accurate?
Then that produces a discovery dispute. And that dispute is the fact that...
Wait, how can they know the transcript is not accurate without seeing the audio, without hearing the audio tape?
I understand the concern, and if the
I mean,
defendant...
isn't that plain? I mean, they have to verify that the transcript is an accurate reflection, and they can't do that unless they have the tape.
If that is the case, the
Wait, I
defendant...
mean, it's plainly the case, I mean, isn't it?
Where that is the case, the defendant is under, has a rule, has a remedy, and it's Rule 14, to bring a motion to... in a timely motion, as soon as that dispute arises. In fact...
But this is a matter of conversation between the defense lawyer, the prosecutor, and the judge. It is openly discussed. We were waiting for this discovery. Why isn't it forthcoming?
I disagree that it was openly discussed as my brother sets forth that it was obvious, that this dispute was obvious. All that was discussed was that discovery was missing. We do not know whether that was automatic discovery.
And transcripts. There was, at least I think, there are points where Mr. Swamley said, I don't have the transcripts. He wasn't just generally saying, I don't have discovery.
Just to correct you, he never said he didn't have the transcripts. He did have the transcripts early on, as Judge Neal found.
He didn't have the
audio.
tapes. I'm sorry.
The first time the defense counsel raised the issue of the audio in open court of the audio recordings was on December 27th, 2007. And on this record, we do not know why at that point or the audio recordings were not turned over. And that...
So should we now have, in addition to all the work that the trial court is facing, have hearings to try to find out where the audio tapes are and things like that? Do judges need to spend their time with that sort of thing?
When it's mandatory discovery.
We disagree that it's mandatory.
Did you
Where
ever
the
make it
transcripts
clear
were
to the
turned-
judge that you disagreed that it was mandatory discovery?
Not on this record.
So if there's something like this that the ordinary mortal would think was mandatory discovery, automatic discovery, and you disagree on that point, you think it's incumbent on the defendant to bring a motion to say that something hasn't been produced because the Commonwealth but hasn't made clear it doesn't regard as being automatic discovery?
Yes, when there is a dispute.
But how do they know there's a dispute? How do they know there's a dispute about something that seems obvious?
In this case, if this issue had been litigated earlier, in fact, it was litigated. When the defendant brought a Rule 14 motion for sanctions regarding the audio recordings, Judge Neal denied that motion, saying that there wasn't prejudice because the transcripts had been turned over early on. The defendant did not appeal that order. That decision, between the time the defendant filed that motion for sanctions and the judge's decision, was 9 days. That could have happened earlier in this case, and it wouldn't have affected what is at issue here, and that is the defendant's speedy trial rights.
Let me ask you this. If we do not accept the view that Mr. Swamley acquiesced in the delay, can you win?
We can.
How?
Because if the defendant is required to object at each date, if this court, in each individual discrete period, and that's what the case law says, if this court finds that his statement of non-waiver, together, I would note, with an agreement to the continuance, is an objection under Rule 36, and you include each of those periods, the 6 times he said, I do not waive Rule 36, the Commonwealth can prevail. We can justify 415.
Right. Let's just try this. Let's assume that from that time that Mr. Swamley first said, until I get automatic discovery, I do not waive my rights under Rule 36. So you have no acquiescence from that point on. Assume that's the position. I'm not saying it will be, but assume that. Can you still win through end of justice grounds for the continuances?
Well, no, through ends of justice, because under Rule 36B2F, where a judge continues a case in the interest of justice, they need to make specific findings on the record. I do not believe that that's on the record in this case. There is no case law for the fact that there is that a standing objection could apply in this case. If this court finds that the defendant can have a standing objection until the Commonwealth provides automatic discovery, which is not clear that there was a delay in this case. If that's the case, then we cannot justify enough time, but there is no support for that proposition.
Wait, but defense counsel is not required to acquiesce in any delay. Defense counsel can say, I acquiesce in no delay.
In this case, defense counsel agreed to virtually every continuance.
Well, that's why I'm asking you whether or not, because of those agreements to the continuances, there are grounds that would permit you to prevail if we find that he did not agree that he was going to waive any Rule 36 rights.
Yes, we can prevail because he did agree. And I would point this, and I guess I just don't,
He did agree to the, I mean, are you saying that the agreement to the continuance constitutes a waiver of Rule 36, or that the agreement to a continuance constitutes a grounds under Rule 36 that would toll the time?
That an agreement to a continuance under Rule 36 tolls the time. And here we have sufficient amount of time told to justify the delay and show that the defendant was brought to trial within 365 days. I apologize, Your Honor. I thought your question was that if he had this standing objection.
Could I ask you this?
That is not what the case law supports.
Put this case aside for a minute. What's wrong with the rule that the BBA is proposing? That is, that as far as automatic discovery is concerned, which is supposed to be delivered at the date by the pretrial conference, getting it does not runs the Rule 36 clock. In other words, you don't have to object all the time. It's just that any time that over the pretrial conference is going to be excluded for Rule 36 purposes, unless the Commonwealth affirmatively says you can't count this because of X, Y, and Z reasons, and the judge says, I find in the interest of justice that that's correct. The Commonwealth's position is correct. What's wrong with that?
I would suggest that the BBA's position is workable if that position is brought to the Rules Committee and the Rules Committee addresses it, with two caveats. First, and the BBA makes this clear, that there has to be a good faith discovery dispute. Taking the audio tapes as an example, in the Commonwealth's position, that was not mandatory discovery, and where there is a dispute, the defendant needs to bring a Rule 14 motion and litigate it. And the second point,
hold on. Let's say the rule is the BBA rule. Why wouldn't it be the Commonwealth's? The dispute is there. The defense attorney says, I want those. I want the tapes, and I think that's mandatory discovery. Why isn't it the burden of the Commonwealth to come in and say, we take a different position. We don't think this. We think this isn't covered by the automatic running of the clock rule. Why isn't that the Commonwealth's burden?
it would be our burden to present that position if the defendant first. The burden would shift to us if the defendant first raises the issue. The defendant didn't raise the issue until he brought his Rule 14 motion after he filed his Rule 36B motion. And I see that I'm running out of time. I want to make one more point about the BBA's position, and they do say that an explicit objection would be required even if automatic discovery is outstanding. And we agree with that position.
Well, if Mr. Swamley indeed had brought a Rule 14 motion, and it had taken a number of weeks to resolve, would you contend that the time is told during the adjudication of that motion?
Yes, as the rule is written,
Okay,
it would be told.
so he was in a position then in which he had to decide whether to file a motion or surrender some of his Rule 36 rights.
That choice would be presented to the defendant, but it's a minimal choice, specifically if we look at here the 9 days that it took to litigate the motion, the Rule 14 motion that he did bring after filing his Rule 36B motion. And I would point to the fact that even if he had brought a Rule 14 motion and the speedy trial clock had been told, it wouldn't affect the trial date. And this case is about Rule 36B and the defendant getting to trial within 365 days absent exclusion.
Well, what could
And I'd like
happen?
to-
What could happen under Rule 14 if the time is excluded? That part of the rule works against the defendant, but doesn't a judge have some flexibility in terms of fashioning sanctions under Rule 14?
Dismissal is not is the draconian one that courts hate.
Yeah,
so.
but if I could finish, isn't one of the things a judge could do is say, after perhaps 30 days, this clock is going to start running against the Commonwealth?
Certainly.
As a sanction under Rule 14.
That could be contemplated because Rule 14 does suggest that the court has discretion to fashion, as you have said, to fashion a sanction, and that could be contemplated. That's not what the rules explicitly say or the case law says, but it is certainly a workable rule. I would like to just point out, if I may, that on May 17th, 2007, the parties filed a joint motion to continue the presumptive trial date in this case. The defendant never said that he couldn't go to trial in August. He said that he wanted to go on vacation and his wife wouldn't let him try the case. And in December, on December 27th, 2007, when the case was again continued, the February trial date was continued, it was continued in part because the defendant wanted testing on certain items of DNA tested. He never said he couldn't go to trial because of the Commonwealth's alleged failure to provide automatic discovery timely. and therefore, under the mechanical operation of Rule 36B, the Commonwealth can justify a sufficient amount of time to show that the defendant was brought to trial within his speedy trial, Rule 36 time limits. Thank you.
Thank you.
Thank you.
Good morning. May it please the court. Kathleen Celio on behalf of the Commonwealth. I ask this court to affirm the defendant's conviction also because the prosecutor's closing argument was fair and certainly did not constitute reversible error.
How is this consistent with Commonwealth versus Lewis?
Because in Commonwealth versus Lewis, you specifically said a prosecutor may address a particular point in the defense's closing argument as a sham, but he may not characterize the entire defense as a sham. And if you look at the entirety of what the prosecutor was saying, he was specifically referencing a claim that defense counsel brought up in his opening, that the evidence would show that Martin McRae was the killer. And the prosecutor was specifically referencing that claim when he said that it wasn't to call it rumor, innuendo, speculation, and then to call it a lie. And then if you look specifically at what the prosecutor said next, he specifically said what evidence supports this outlandish claim. It's a proposition that's simply not true. It was all focused on that claim and showing why the evidence did not support that claim.
Okay, but how do you go so far as to say you violate your oath if you accept the defense theory?
Because if you the jurors took an oath at the beginning of the trial to follow the evidence and to follow the law. So his point in telling the jurors that if you that you could find Martin McRae, because exactly what he said right before that was, you can find Martin McRae is unbelievable, but find it based on the evidence. You can't believe it based on the speculation, the innuendo, the claim that Martin McRae was the killer.
Right, try my question. Is it appropriate for a prosecutor to say that you violate your oath if you accept the defense theory of a case?
I don't think that's what the prosecutor did in this case, respectfully. What he was saying is that he was focusing on the evidence, the claim that there was no evidence that Martin McRae was the killer. That was a claim of defense counsel.
But he did speak about you violate your oath.
That is correct, because they took an oath to follow the evidence. And that was his point. And that is exactly what he told the jurors. They needed to follow the evidence. And his entire closing argument was focused on what the evidence was. And if you look at the conversation that the prosecutor and defense counsel had with Judge Neal the next day, Judge Neal, who was there, who witnessed it, understood what the intent was that this prosecutor had for them to be able to focus on the evidence. And I also think, just in conclusion...
Well, he did give a curative instruction.
He did also give a clear instruction to follow the evidence.
So he did find it to be error.
That was... He said he was troubled about it. We disagree with that. But he said that it was the intent, based on the prosecutor's entire closing argument, that was focused on the jury focusing on the evidence. And also, if you look at it, the jury deliberated for 5 days. With all due respect to both Mr. Zabin and Mr. Swamley, I don't think that the jury was so... not to say impressed, but had the force that they had wanted it when the jury was there for 5 days, 30 to 40 hours, focusing on what they were focused on was the evidence. And the evidence that they had in the jurors' instructions. And that's what they did, and that's how they found this defendant guilty of second-degree murder, which I asked this court to affirm that conviction.
Thank you, counsel.
Thank you, counsel.